Why can California ban something that Texas allows? Why can the federal government step in and then suddenly step back? This isn't chaos. This isn't a loophole. It's one of the oldest power struggles in American history, a battle written into the DNA of the United States itself. For over 200 years, America has been locked in a tug-of-war between states' rights and federal power. This fight has sparked rebellions, fueled a civil war, reshaped civil rights, and still decides what laws control your life today. So who should really be in charge? Washington or the states? To answer that, we have to go back to the very beginning. Have you ever wondered why a law in California is completely different from one in Texas? Or why the federal government can tell states what to do sometimes, but not always? This is the core of one of America's oldest and most heated arguments, the battle between states' rights and federal power. It's a debate that started with the Founding Fathers and continues to shape our lives every single day, from healthcare and education to what we can buy and how we live. So where do you draw the line? Let's dive into this epic tug-of-war that defines the United States. To really get this, we have to go back to the very beginning, even before the Constitution. After declaring independence from a powerful king, the newly formed states were terrified of creating another strong central government. Their first attempt was the Articles of Confederation. Under this system, the states were basically their own little countries, loosely allied. The federal government was incredibly weak. It couldn't even collect taxes effectively. If it needed money, it had to politely ask the states, and they could just say no. As you can imagine, this didn't work out so well. The country was broke, and Shays' Rebellion, an uprising of frustrated farmers in Massachusetts, showed just how powerless the central government was to maintain order. It was clear something had to change. So in 1787, delegates gathered for the Constitutional Convention. They weren't just there to tweak the articles. They ended up drafting a whole new rule book, the U.S. Constitution. This is where the real fight began. On one side, you had the Federalists, like Alexander Hamilton and James Madison. They argued for a stronger national government, one that could unite the country, regulate commerce, and provide for a common defense. They believed a robust federal authority was essential for the nation's survival and prosperity. On the other side were the anti-federalists, like Patrick Henry and George Mason. They were deeply suspicious of centralized power, fearing it would stomp all over individual liberties and the sovereignty of the states, just like the British monarchy they had just escaped. The result was a masterpiece of compromise. The Constitution created a system of federalism, where power is divided between the national government and the state governments. The federal government was given specific enumerated powers, like the power to declare war, coin money, and regulate interstate commerce. But to calm the fears of the anti-federalists, the 10th Amendment was added as part of the Bill of Rights. It's super important. It says that any powers not specifically given to the federal government nor prohibited to the states are reserved for the states or the people. This amendment is the cornerstone of the states' rights argument. It's like the Constitution drew a line in the sand, but over the next 200+ years, everyone would argue exactly where that line is. The first major test came early on with the Necessary and Proper Clause, also known as the Elastic Clause. This clause gives Congress the power to make all laws which shall be necessary and proper for carrying into execution its foregoing powers. Federalists, like Hamilton, saw this as giving the federal government implied powers to do things not explicitly listed in the Constitution, like creating a national bank to stabilize the economy. Thomas Jefferson and his followers, however, had a stricter interpretation. They argued that if the Constitution didn't explicitly say Congress could do it, then it couldn't. This debate culminated in the landmark Supreme Court case McCulloch v. Maryland in 1819. The court sided with Hamilton's view, ruling that the federal government did have implied powers and that federal laws trumped state laws when there was a conflict. This was a huge win for federal power. But the biggest and most tragic conflict over states' rights was without a doubt the Civil War. While slavery was the fundamental cause, the political argument used by the Southern states to justify secession was states' rights. They claimed the federal government had no right to interfere with their peculiar institution or their way of life. They argued that since the states had voluntarily joined the Union, they had the right to voluntarily leave it. Abraham Lincoln and the Union government completely rejected this idea. The Union's victory in 1865 was a decisive blow against the most extreme version of states' rights and firmly established that the United States was one nation, indivisible, not just a loose confederation of states. The federal government's authority was cemented. Following the Civil War, a series of constitutional amendments, the 13th, 14th, and 15th, further expanded federal power, particularly in protecting civil rights. The 14th Amendment is especially crucial, guaranteeing equal protection under the law to all citizens and applying the Bill of Rights to the states. For a long time, this was used to strike down state laws that discriminated against African Americans. The 20th century saw another massive expansion of federal power, largely driven by two major events, the Great Depression and the Civil Rights Movement. During the Great Depression, President Franklin D. Roosevelt's New Deal programs created a vast array of federal agencies and social safety nets, like Social Security. The federal government got into people's lives in ways it never had before, regulating the economy, creating jobs, and providing direct aid. The Supreme Court initially resisted, but eventually came to accept this broader interpretation of federal authority, especially under the Commerce Clause, which gives Congress the power to regulate commerce among the states. Then, in the 1950s and 60s, the Civil Rights Movement put the federal government and states on a collision course once again. Southern states used the banner of states' rights to defend segregation laws, but the federal government, through landmark Supreme Court decisions like Brown v. Board of Education, which desegregated schools, and historic legislation like the Civil Rights Act of 1964 and the Voting Rights Act of 1965, intervened directly to dismantle segregation. Federal troops were even sent to enforce desegregation in states that resisted, a powerful demonstration of federal supremacy. Starting in the 1980s, however, the pendulum began to swing back. There was a growing movement, often associated with President Ronald Reagan, pushing for de-evolution, the idea of transferring power from the federal government back to the states. This conservative movement argued that states were more innovative, efficient, and responsive to the needs of their citizens. They believed a one-size-fits-all approach from Washington often didn't work. The Supreme Court also began to reflect this shift, with rulings that limited the scope of federal power under the Commerce Clause for the first time in decades. So where does that leave us today? The debate is as alive as ever. You see it everywhere. Take environmental regulations. California often sets stricter emission standards than the Federal Environmental Protection Agency, and other states choose to follow California's lead. This creates a patchwork of rules across the country. Or look at healthcare. The Affordable Care Act, or Obamacare, was a major federal initiative, but states have had significant leeway in how they implement it, with some expanding Medicaid and others choosing not to. We see the same dynamic with education, where federal standards like No Child Left Behind or Common Core have faced major pushback from states who want more control over their curriculum. And in recent years, we've seen major clashes over things like voting laws, gun control, and abortion rights. After the Supreme Court overturned Roe v. Wade, the authority to regulate or ban abortion returned entirely to the states, creating one of the starkest examples of the states' rights versus federal power divide in modern history. One state might almost completely ban it, while a neighboring state protects it, leading to a complex legal and social landscape. The legalization of marijuana is another perfect example. Federally, it remains illegal, but dozens of states have legalized it for medical or recreational use, creating a direct conflict between state and federal law. This delicate dance continues because the federal government has largely chosen not to enforce its laws in states that have legalized it. So what's the takeaway from all this? The tension between states' rights and federal power isn't a flaw in the American system, it's a feature. The founders designed it this way. This constant tug of war forces debate, encourages experimentation at the state level, what some call the laboratories of democracy, and ideally prevents any one level of government from becoming too powerful. But it also leads to inequality, confusion, and intense political conflict. There's no easy answer, and the right balance is always shifting, depending on the issue and the political climate. What do you think? Should the federal government have more power to ensure uniformity and equality? Or should states have more freedom to chart their own course?